For real estate exam concepts made simple, go to prepagent.com. Today we're going to go over some California real estate exam questions that gave some people some trouble. Let's get right to it. After a trustee sale, there is money left over after paying the beneficiary of the first trustee. This money would go first to the A. Trustor, B. Beneficiary of the second, C. State, or D. Beneficiary of the first. The answer is beneficiary of the second. When you can't make your payments, a trustee sale will take place. It's a form of foreclosure. Let's say you take out two loans on your property. You owe $100,000 to the first lender and $50,000 to the second lender. If the property forecloses for $110,000, then the first lender will get the $100,000 back in full. The second lender, or the beneficiary of the second, will get what's remaining. In other words, they will get $10,000 towards the $50,000 that is owed to them. The owner of a property encumbered with a first and second trustee wants to refinance the first trustee. What should the second trustee contain? A. A subordination clause. B. An exculpatory clause. C. A release clause. Or D. An acceleration clause. The answer is subordination clause. A subordination clause is a clause which states that that mortgage will always take a subordinate position. So in this case, there's a first trust deed. When you refinance a loan, you're essentially getting a brand new loan. So when they refinance that first trust deed, a new loan came in. However, that new loan will still take priority because the second loan has a subordination clause, which states that it will take a subordinate position to a subsequent lien, the other loan. A veteran may purchase a home under CalVet by A. Contract of sale, B. Trust deed, C. Mortgage, D. Any of the above. The answer is contract of sale. CalVet mortgages are procured using a contract of sale. Basically, the CalVet purchases a qualified military veteran's desired property and then sells it to him using that contract of sale, sometimes known as a land contract. The CalVet program actually holds legal title to the home bought with a CalVet mortgage, while the military veteran holds equitable title. Remember, equitable title means the right to use and possess. In purchasing a home, the purchaser generally gives a note secured by a first deed of trust to a lending institution. In addition, he may give the seller cash and a note secured by a second deed of trust on the property. A request of notice would be filed for the benefit of the A. Mortgagor, B. Holder of the second, C. Trustor, D. Holder of the first. The answer is holder of the second. Remember, the first mortgage takes priority over the second. Therefore, if the first mortgage is not being paid, then the second needs to know about it. So the first doesn't get paid, the second can't be paid. And that notification is called a request of notice of default. A request of notice of default is filed with the county recorder when the second trust deed is recorded. If there is a default on the first trust deed, the recorder will send a copy of the notice of default to the holder of the second. This gives the holder of the second time to reinstate the first and begin foreclosure on the second. They need to reinstate that first loan because it takes priority over theirs. If that one's not getting paid, then theirs can't get paid. So they need to reinstate the first, and then they could go through the process of getting their money back for that second loan. The trustor under a trust deed is the party who A. Signs the note as the maker, B. Holds the title to the property in trust, C. Acknowledges the note for recording, D. Lends the money. The answer is A. Signs the note as the maker. The trustor is the borrower under a deed of trust and is the one who signs the note and deed of trust. Remember, the trustor is the giver of that note. They retain equitable title. The trustee receives it on behalf of the beneficiary and retains what is called legal title, the right to sell. The note they are referring to is the evidence of the debt. Under the power of sale clause on a trust deed, the authority to sell is placed with A. County sheriff by court order, B. Clerk of the county court by court order, C. Trustee by the trustor, D. Beneficiary by trustee. The answer is C. Trustee by the trustor. The power of sale clause is found in a trust deed where the trustor gives the trustee authority to sell the property under certain circumstances. What the trustee has is legal title. Remember, the trustor is the giver, trustee receives. Which of the following holds title under a CalVet loan? A. Trustor, B. Buyer, C. Veterans Administration, or D. State of California. The answer is State of California. CalVet loans are administered by the California Department of Veterans Affairs, also known as the CalVet. The CalVet buys the select property from the seller and resells the property to the veteran on a land contract. They buy the property and resell it to the veteran so they can give a much better deal for the veteran than they would otherwise be able to get. This is done as a thank you for serving our country. The Aliquist-Priolo Earthquake Fault Zoning Act resulted in the establishment of earthquake fault zones. How wide is the typical zone boundary? A. 1/4 mile, B. 1/2 mile, C. 3/4 mile, D. 1 mile. The answer is 1/4 mile. The Aliquist-Priolo Special Studies Zone Act of 1972, renamed the Aliquist-Priolo Earthquake Fault Zoning Act in 1994, regulates development and construction of buildings intended for human occupancy in earthquake fault zones. The typical zone boundaries are set back approximately 660 feet on either side of the fault trace, or 1/4 mile in width. Easy way to remember the Aliquist-Priolo Act is for earthquakes, just remember the cues: Aliquist earthquake, Aliquist earthquake. You are a California real estate broker. A prospect is referred to you by an out-of-state broker and a sale is consummated by you. You want to split your commission with a cooperating broker. Under the California real estate law, A. You may pay a commission to a broker from another state. B. You cannot divide a commission with a broker of another state. C. You can pay a commission to a broker of another state only if he/she is also licensed in California. D. None of the above. The answer is A. You may pay a commission to a broker of another state. A California licensed real estate broker may pay a commission to a broker of another state as long as they comply with the real estate laws and the real estate licensing laws of their respective state. An unlicensed assistant puts together information and assists in writing an advertisement for a broker. For this to be legal, the broker must A. Write it himself, B. Approve it, C. Terminate the assistant immediately, or D. Proofread it. The answer is B. Approve it. An unlicensed assistant can prepare and design advertising relating to the transaction for which the broker was employed, if the advertising is reviewed and approved prior to its publication. This is essentially paperwork. An unlicensed person can help the broker with paperwork. The gist of what an unlicensed person cannot do is they cannot solicit business. That is a licensed activity. That's all for now. This is Joe from PrepAgent.com. trying to make real estate concepts simple.